Cato's Letter number 11, January 7th, 1721. The justice and necessity of punishing great crimes, though committed against no subsisting law of the state. Signed, Thomas Gordon. Published in the London Journal, Saturday, January 7th, 1721.
Sir, salus populi suprema lex esto, that the benefit and safety of the people constitutes the supreme law, is a universal and everlasting maxim in government. It can never be altered by municipal statutes. No customs can change. No positive institutions can abrogate. No time can efface this primary law of nature and nations. The sole end of men's entering into political societies was mutual protection and defense, and whatever power does not contribute to those purposes is not government, but usurpation.
Every man in the state of nature had a right to repel injuries and to revenge them. That is, he had a right to punish the authors of those injuries and to prevent their being again committed. And this he might do without declaring beforehand what injuries he would punish. Seeing therefore that this right was inherent in every private man, it is absurd to suppose that national legislatures, to whom every man's private power is committed, have not the same right, and ought not to exercise it upon proper occasions.
Crimes being the objects of laws, there were crimes before there were laws to punish them. And yet from the beginning, they deserved to be punished by the person affected by them, or by the society, and a number of men united with him for common security, though without the sentence of a common judge, called by us the magistrate, formally appointed to condemn offenders.
Laws, for the most part, do not make crimes, but suit and adapt punishments to such actions as all mankind knew to be crimes before. And though national governments should never enact any positive laws, never annex particular penalties to known offenses, yet they would have a right, and it would be their duty, to punish those offenses according to their best discretion, much more so if the crimes committed are so great that no human wisdom could foresee that any man could be wicked and desperate enough to commit them.
Lawyers distinguish betwixt malum prohibitum and malum in se, that is, between crimes that are so in their own nature and crimes that owe their pravity to a disobedience to positive laws. Of the former sort are those actions by which one man hurts another in his reputation, his person, or his fortune. And those actions are still more heinous if they injure or are intended to injure the whole society.
The latter sort consists of such crimes as result from what legislatures enact for the particular benefit of private societies, as laws concerning the regularity of trade, the manner of choosing magistrates, local orders, and from such positive institutions as receive their force alone from the powers that enact them. Now those crimes were not so before they were declared so, and consequently no man before was under any obligation to avoid them.
It would be very severe and unjust to punish any man for an undesigned transgression of the latter sort, that is, for such action as he thought that he might lawfully and honestly do, and which he had never notice given him not to do. But to infer from thence that a villain may despise all the laws of God and nature, ruin thousands of his fellow subjects, and overturn nations with impunity, because such villainy was too monstrous for human foresight and prevention, is something so absurd that I am ashamed to confute it.
This is nothing less than asserting that a nation has not a power within itself to save itself, that the whole ought not to preserve the whole, that particular men have the liberty to subvert the government which protects them, and yet continue to be protected by that government which they would destroy, that they may overturn all law, and yet escape by not being within the express words of any particular law.
There are crimes so monstrous and shocking that wise states would not suffer them to stand in their statute books, because they would not put such an indignity upon human nature as to suppose it capable of committing them. They would not mention what they imagined would never be practiced. The old Romans, therefore, had no law against parricide, yet there was no want of punishment for parricides from the want of law. Those black and enormous criminals were sewed up in a sack and thrown into the Tiber.
In Holland, there was no law against men's breaking fraudulently, yet the first man who was known to do so was immediately executed, and his estate divided among his creditors.
In England, 'tis said there was no law till lately against the burning of ships. Yet if any man had burned the Royal Navy of England lying at anchor, ought not his crime, which it seems was not felony, to have been declared high treason?
Many nations have had particular officers appointed on purpose to punish uncommon crimes, which were not within the reach of ordinary justice. The Romans had a dictator, a great and extraordinary magistrate, vested with an extraordinary power, as he was created on extraordinary exigencies, and his commission was limited only by the public good, and consisted in a very short direction, necvid detrimenti res publica capiat, in English, to save the state.
This powerful officer was once created on purpose to put to death Spurius Malleus for giving gratis to the people a large quantity of corn in a time of famine. This liberality of his was construed by the Senate an ambitious bribe to catch the hearts of the multitude in order to seize their liberties. Spurius Malleus predivis rem utilem pessimo exemplo pehori concilio est egressus. He undertook a public and plausible thing, but of ill example and with a worse design. Largitonius frumente facere instituit. His avowed pretense was to relieve the poor. Plebem hoc muneri dilintem cancunc incederet conspectus alatusc supra modem homines privite secum traere. He cajoled the people, intending to enslave them, and growing too powerful for a subject, became terrible to the common liberty, which is supported by equality. Ipse ut est humanis animes insatiabilis eu quod fortuna spondet e altiora e non concessa tendere. The mind of man is restless and cannot stand still nor set bounds to its pursuits. It is not to be expected that one of our 1,000,000 men, and they say that we have several, will sit down and be content with his millions, though he were allowed to keep them, which God forbid. He will be making new pushes for new acquisitions, having such ample means in his hands. Spurius Malleus would at first have been content with the consulate or chief magistracy in ordinary, but because he found that even that could not be got without force, he thought that the same force would as well carry him higher and make him king. Et coniam consolitus cuque eripindus invitus patribus esset de regno agitare. The traitor had been suffered to carry a great point. He had abused the public and deceived the people. The Senate, therefore, took him to task, and there being no law subsisting by which he could be put to death, consules legibus constricti ne concam tantum vidium in magistratu e anem rem pro atrocitate vindicandum contum anime aberrant. They therefore created a dictator, an officer with power, for a time, to suspend laws and make laws. The occasion was great. Opus esse non forti solum vido, sed etiam libero ex solitu que legum vinculis. Lucius Quintius Cincinnatus was the man, a true and brave old republican who worthily and boldly did his work, and by the hands of his master of the horse slew the mighty traitor, impudently imploring the public faith to which he was a sworn enemy, and complaining of the power of oppression when the shameless villain had been only seeking a power to oppress. Fidum plebis Rominae implorari, and opprimi se constancy pratrum discere. He knew that his villainies were out of the reach of the law, and he did not dream of an extraordinary method of punishing them by the Roman Parliament. But he was deceived, and the dictator tells the people that, being a sort of outlaw, he was not to be proceeded with as with a citizen of Rome, nec cum etancum cum sivi adjundum fuisi. An unusual death was due to his monstrous wickedness. Non proseclere id magis com pro monstro abendum. Nor was his blood alone, says the wise dictator, sufficient to expiate his guilt, unless we also pull down his house, where such crying crimes were first conceived, and confiscate to the public use his estate and his treasures, the price and means of the public ruin. And his estate was accordingly given to the public. Nexatis esse sanguine, ejus expatium nisi tecta, parietus interque tantum, aminince conceptum esit, dissiparentur bonac contacta praetis regni, mercandi publicarentur, jubere itac cestres vendere et bona in publicum redigere. The treasury had them for the use of the public.
Thus did the great, the wise, and the free Romans punish this extraordinary knave by a power that was not ordinary. They likewise exerted it upon other occasions, nor were they the only people that did so. The Athenians, grown jealous by having lost their liberties, by the usurpation of a private but too powerful citizen, durst never trust this great power to any single magistrate or even to a council. They would not, however, part with it, but reserved it to the whole body of the people, agreeably to the nature of a popular government. In this jealous state, it was a crime to be popular, much more to affect popularity. They would not allow a man to have it in his power to enslave his country. And indeed, it is wisdom in a state, and a sign that they judge well to suppose that all men who can enslave them will enslave them. Generosity, self-denial, and private and personal virtues are in politics but mere names, or rather cant words, that go for nothing with wise men, though they may cheat the vulgar. The Athenians knew this, and therefore appointed a method of punishing great men, though they could prove no other crime against them but that of being great men. This punishment was called the ostracism, or the sentence of a majority in a ballot by oyster shells, by which a suspected citizen was adjudged to banishment for 10 years. They would not trust to the virtue and moderation of any private subject, capable, by being great, to be mischievous, but would rather hurt a private subject than endanger the public liberty. Worthy men are thought to have suffered unjustly by this ostracism, and it may be true, for aught that I know, but it still secured the public, and long secured it. Weak and babbling men, who penetrate no deeper than words, may blame this politic severity in the Commonwealth of Athens, but it is justified in that it was politic.
In Venice, a wise, ancient, and honorable republic, there is a council of 10 which exercises this extraordinary power. Every arbitrary prince in the world exercises it, and every free state in the world has an undoubted right to exercise it, though they have never delegated their power to particular magistrates to exercise it for them.
In England, indeed, we have not delegated this power at all, because we very well know who must have had it, and what use would be made of it. The legislature, therefore, has reserved this power to itself, and has an undoubted right to exercise it, and has often done so upon extraordinary occasions. It ought indeed to be exercised but upon extraordinary occasions. Jove's thunderbolts were only launched against such as provoked the thunderbolts of Jove.
I shall, in my next letter to you, apply these general maxims of government to our own particular constitution and to the present occasion, which calls aloud for Jove's help and thunder. I am, etc., Thomas Gordon. Action.
January 14th, 1721. Of treason. All treasons not to be found in statutes. The right of the legislature to declare treasons. Signed, John Trenchard. Published in the London Journal, Saturday, January 14th, 1721.
Sir, treason, properly so called in Latin crimen lese majestatis, is in all countries the same. It is an endeavor to subvert or to do some notable mischief to the public, of which every man is a part, and with which he has joined himself for mutual defense, under what form soever the administration is exercised. I own that lesser crimes are sometimes called by the same name and subjected to the same punishment.
An attempt to destroy the chief magistrate of a commonwealth, or the general of an army in the field, or the governor of a town during a siege, are certainly treasons everywhere, because in such attempts, when they succeed, are often involved the ruin of states. They also are doubtless guilty of high treason, who, being entrusted with the wealth, security, and happiness of kingdoms, do yet knowingly pervert that trust, to the undoing of that people whom they are obliged, by undeserved rewards, as well as by all the ties of religion, justice, honor, and gratitude, to defend and protect.
'Tis the same if any number of men, though in a lesser trust or in no trust at all, should deliberately and knowingly destroy thousands of their fellow subjects, and overturn the trade and public credit of the nation to enrich themselves and their accomplices.
These, and the crimes of the like nature, are treasons from the nature of things themselves, antecedent to all laws that call them so, and will be treasons, though laws gained by subordination should call them otherwise. And every state has a right to treat those who commit them as traitors and parricides. In truth, there are as many of these kinds of treasons as there are different methods of conspiring against kingdoms, and the criminals, though ever so great, deserve death and confiscation. That is, they ought to be destroyed by the people whom they would destroy.
The great principle of self-preservation, which is the first and fundamental law of nature, calls for this procedure. The security of commonwealths depends upon it. The very being of government makes it necessary, and whatever is necessary to the public safety is just.
The fate of millions and the being of states must not stand and fall by the distinctions of monks, coined in colleges, or by the chicane of pettifoggers, who would bring everything within the narrow verge of their own knowledge, under their own jurisdiction and cognizance, and would determine all things by the rules of inferior judicatures, the gibberish of private practicers, and the sayings of old women, or those who are like old women, whose brains are addled by being long jumbled and always turned round within the scanty circle of private courts, not daring to venture at a bold and free thought out of them, however self-evident, like some carriers' horses that are used to a track and know not how to travel in an open road.
But questions of this kind belong ad alium examen and ought to be brought before a higher tribunal. The legislature are the only proper and safe judges. What is done against all should be judged by all. Nor are their resolutions to be confined by any other rule than quid est utile, quid honestum, general justice and the general good. Religion, virtue, common sense, and the public peace and felicity are the only counsel to be admitted either for the public or the prisoners.
The conspirators against mankind ought to know that no subterfuges or tergiversations, no knavish subtleties or pedantic quirks of lawyers, no evasions, skulkings behind known statutes, no combinations or pretended commissions, shall be able to screen or protect them from public justice. They ought to know that there is a power in being that can follow them through all the dark labyrinths and doubling meanders, a power that can crush them to pieces, though they change into all the shapes of Proteus, to avoid the fury of Hercules, a power confined by no limitation but that of public justice and public good, a power that does not follow precedents but makes them, a power which has this for its principle, that extraordinary crimes ought not to be tried by ordinary rules, and that unprecedented villainies ought to have unprecedented punishments.
But though in all governments this great power must exist somewhere, yet it can rarely be delegated with prudence to inferior magistrates, who, out of ambition, revenge, or faction, or for bribes and preferments, or out of fear and flattery, or in concert with the ill measures or selfish intrigues of statesmen, may pervert so dangerous a trust to the destruction of those whom it was intended to preserve.
This particularly has been the case of England. We know by what means judges were often made, and from what conduct they expected further preferment, and from whom they looked for protection. For this reason they were, and ought to be, confined in their jurisdiction relating to treason, and the manner of trying it.
Undoubtedly, every intention manifested by acts to destroy the Constitution and government was treason by the common law of England. But why do I say of England, since it is, and ever was, treason in every country throughout the world? This treason equally extends to those who would subvert either House of Parliament or the rights and privileges of the people, as to those who attempt to destroy the person of the king or dethrone him. And indeed, what can be more absurd than to suppose it to be the highest crime to attempt to destroy one man, for no other reason but that he is king, and yet not to suppose it the highest crime to destroy that people for whose benefit alone he was made king, and for whose sake indeed there ever was such a thing in the world?
But though this proposition was self-evident, and must ever be assented to as soon as mentioned, yet, by the flattery of priests and servile lawyers, the salus populi, or security of the state, soon came to signify only the unbounded power and sovereignty of the prince, and it became treason to hinder one, constituted and grandly maintained out of the people's labor and wealth, for the public safety, from destroying the public safety. Our ancestors found, by lamentable experience, that unworthy men, preferred by corrupt ministers for unworthy ends, made treasons free only of the court, that the least attempt to oppose unlimited and unlawful authority was often called treason, and that the highest treasons of all, which were those against the commonwealth, might be committed with impunity, applause, and rewards.
It was therefore high time to apply an adequate remedy to an enormous mischief, which struck at the whole state and at the fortunes and lives of every subject in England. The statute, therefore, of the 25th of Edward III was enacted, which enumerates the several species or kinds of treason, which shall continue to be esteemed treasons, and be adjudged so by the king's justices, and are chiefly those which relate to the king's person, his family, and dignity. These the Parliament thought they might safely trust to the examination of the king's judges, under such limitations and regulations as the Act presents.
But it is plain from the same Act that they did not intend to confine all treasons to those recited there, because it is declared in the following words: If any other case suppose treason, not before specified, shall happen before any justices, they shall stay judgment, till the cause be showed before the Parliament, whether it ought to be judged treason or not.
So that here is a plain declaration of the legislature, if any man can possibly think such a declaration wanting, that other crimes were treason, and ought to be punished as treason, though not by the king's judges, besides those recited in the Act, which were, as has been said, designed only to extend to treasons which were committed against our Lord the King and his royal majesty, as the Act expressly says. And 'tis evident from the whole tenor of it that it was intended purely to restrain the unlimited and exorbitant jurisdiction assumed by the king's courts in declaring treasons, and sacrificing by that means whom they pleased to unlawful power.
But as to the highest and most heinous treasons of all, such as were treasons against the legislature, and against the whole body of the people, for whose safety alone there were any treasons against the king at all, seeing that their safety was, in a great measure, included in his, the Parliament reserved the judgment of every such treason to themselves. They did not alter what was treason, but the judges of it. They knew that treasons against the Constitution could seldom be committed but by ministers and favorites of princes, protected by power and sheltered by authority, and that therefore would be absurd to trust the punishment of such potent knaves and criminal favorites to judges made by themselves, judges who would neither have inclination, figure, or character to reach crimes countenanced and perhaps authorized by a Richard II or Edward II.
Such crimes, therefore, were the proper objects of the awful power of a legislature, who will always be supported by the people whom they represent, when they exert themselves for the interest of that people. A power so supported can make the loftiest traitor quake. It can fetch corrupt ministers out of their dark recesses and make their heads a victim to public vengeance. Every wise and good king will lend a willing ear to their dutiful remonstrances. He will hearken to the importunate cries of his people and readily deliver up the authors of their misery.
One great part of their care, therefore, has ever been to call those to an account who have abused the favor of their royal master, and endeavored to make him little and contemptible to his people, weakening, by such means, his authority, and hazarding his person. This the people whom they represented thought they had a right to expect and demand from them, and this justice they have often done to their king and country.
An excellent discourse concerning treasons and bills of attainder was published soon after His Majesty's accession to the throne, and showed unanswerably that our parliaments, in almost every reign since the conquest, claimed and exercised this right upon extraordinary occasions, and none ever till lately opposed it but the criminals who were to suffer by it and their party. Some gentlemen now living can give the best account why that book and the cries of every honest man had not their desired effect. I hope that no man will be deluded again by any practicing the same arts, and for the same reasons too.
The length of this letter will not allow me to draw from all these reasonings upon treason such applications as I promised in my last, and intended in this. I shall therefore defer these applications to another, and perhaps more proper occasion. In the meanwhile, I observe with pleasure the noble spirit shown by our legislature to punish, with an exemplary severity, the murderers of our credit, and the public enemies of our liberty and prosperity. This revives every drooping heart, and kindles joy in every face, in spite of all our miseries. And this brings terror, trembling, and paleness upon the guilty, to see death and destruction pursuing them close, and besetting them hard on every side. They are in the circumstances and agonies of the guilty Cain, who justly feared that every man whom he met would kill him, though there was no law then in being against murder. I am, etc.